What's going on YouTube? Listen up, young elder gang. This is Shalonda Lewis. At you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning. The truth, keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only and does not constitute legal advice. Common and private law cases are complex, and self-representation is highly discouraged by the elites. Seeking legal counsel from a qualified attorney is essential for navigating the legal system and maximizing your chances of success. We will give you the total truth as we best understand it today. Be sure to hit that like button. Young Elder Gang, hit that subscribe button. If you're new to the channel, hit that bell and don't forget to check back with us every day for new content. I reckon if you've ever wondered what happens when neighbors argue about a fence, or why judges quote old cases, you're closer to the answer than you think. Let's break it down, simple as sweet tea. Picture this. Private law is like sorting out who gets the last slice of pie at a family reunion. It handles squabbles between people or companies, things like contracts, property, or who's responsible when Aunt Sue's casserole ends up on the floor. It's all about folks dealing with folks, not the government. Now, common law? That's more like a family recipe handed down for generations. Instead of everything written down in one big book, judges make decisions, and those decisions become the rules everyone follows. Kinda like, well, we've always done it this way. Here's the kicker. You can have private law inside a common law system. The difference? Private law is about who's involved. Common law is about how the rules get made. Let's get started. Don't be a dummy. Know your law. Every day you make decisions and sign papers, but do you know the rules you're playing by? The law isn't just for lawyers or criminals. It's everywhere, from your morning coffee to your lease agreement. If you don't understand the basics, you're walking blind. We're talking about two big ideas, common law and private law. Don't let the terms scare you. This is real-world info to protect yourself and your family. Understanding these concepts is the difference between being a victim and being in control. Many people mix up what a judge decides in court with the contract they sign for their phone. Common law is the stage, built by judges over centuries. Private law is your script, the agreements you make and the responsibilities you have. If you don't know the difference, you're setting yourself up for trouble. Life is full of disputes. A neighbor's tree falls on your car. A company sells you a defective product. Your business partner cheats you. These are your problems, not just government problems. Knowing whether you're dealing with a broken agreement or a principle from a past case is your first step to a solution. The more you know, the less likely you are to get taken for a ride. Don't be a knucklehead. What in the world is common law? It's not that complicated. Common law is judge-made law built up over centuries, one case at a time. When a judge makes a decision, it becomes a precedent, a guide for future cases. Think of it like a family recipe, passed down and tweaked for new situations. This system started in England, where judges used local customs and common sense to make rulings. Over time, the best rulings were shared, creating a common law for the whole kingdom. Countries like the US, Canada, and Australia inherited this system. When you hear about a landmark case, that's common law in action. A new precedent is set. For example, innocent until proven guilty is a cornerstone of common law, reinforced by countless decisions. Common law is about consistency and predictability, but it's not stuck in the past. As society changes, so does the law. Think about how judges now apply old principles to the internet. There were no laws about cyberspace 50 years ago, so judges use old ideas about privacy and property to create new rules. It's a slow process, but it lets the law adapt without needing a new law for every situation. Judges look at old cases about trespassing and apply them to hacking or digital privacy. Common law is practical, flexible, and always evolving. It's the foundation of our justice system, and it's everywhere, even if you don't see it. And what about private law? It's all about you and your neighbor. Private law governs relationships between individuals, your rights and obligations to others. It's about your money, your property, and your promises. The biggest areas are contracts and torts. A contract is a legally binding promise, like signing a lease or buying a TV with a warranty. If someone breaks their promise, private law helps you fix it by making them do what they promised or pay for the damage. A tort is a civil wrong, like negligence. If you text and drive and cause an accident, you're liable for the harm. Private law covers property, family, and business law. Who owns what? Marriage and divorce, how companies make deals. It's the rule book for everyday life, keeping things orderly. Without it, every disagreement would be chaos. Private law gives us a civilized way to resolve disputes. It's personal, practical, and everywhere. Know it, and you'll avoid a lot of trouble. All right, time for a quick history lesson. Common law comes from England, but its roots go deeper. Roman law and ancient moral codes shaped its core ideas. Roman law influenced Europe's civil law system, with organized codes for almost every situation. England took a different path, but borrowed categories like property, contracts, and torts. Private law is as old as civilization. People needed rules for property and deals from the start. The Code of Hammurabi had rules about goods, rentals, and builder liability, problems we still face today. When you're in court, you're part of a centuries-old conversation about justice and fairness. Common law gives us the philosophy. Private law gives us the tools. Together, they form the framework we rely on today. All right, time for a quick history lesson. Common law comes from England, but its roots go deeper. Roman law and ancient moral codes shaped its core ideas. Roman law influenced Europe's civil law system, with organized codes for almost every situation. England took a different path, but borrowed categories like property, contracts, and torts. Private law is as old as civilization. People needed rules for property and deals from the start. The Code of Hammurabi had rules about goods, rentals, and builder liability, problems we still face today. When you're in court, you're part of a centuries-old conversation about justice and fairness. Common law gives us the philosophy. Private law gives us the tools. Together, they form the framework we rely on today. Let's make this simple. You buy a new smartphone. That's private law, a contract between you and the store. The fine print you ignore? That's part of your agreement. If the phone's battery explodes and injures you, you have a private law claim. Maybe the company broke its warranty. You might sue for the cost of the phone and your medical bills. But what if the company says it's not responsible? That's where common law comes in. Your lawyer looks up past cases about defective products. Judges have set precedents. Manufacturers are responsible for injuries from defective products. The judge in your case uses those precedents to decide what happens. Common law provides the rules. Private law is how you enforce them. Your dispute is private law, a contract, and a tort. But the judge's decision is guided by common law. One is the what, your problem. The other is the how it's resolved. They work together. It's a partnership. That's how the system keeps things fair. Here's another key difference. Private law versus public law. Private law is about rules between equals, you and your neighbor or a company. Public law is vertical. It's you versus the government. Public law includes criminal, constitutional, and administrative law. If your neighbor punches you, you can sue for medical bills, private law, but the government can also charge him with assault, public law. One action compensates you, the other punishes him and protects society. Taxes? That's public law. You pay because the law says so, not because you agreed to it. If you don't pay, the IRS comes after you. Your rights, like free speech, are protected by public law, limiting government power. Private law is about your responsibilities to others. Don't confuse a private dispute with a violation of your constitutional rights. They're different animals. Know the difference. It matters. So, why does this matter? Because not knowing the rules is the fastest way to lose. Every day you deal with common and private law. Leases, car deals, jobs, accidents. Ignorance costs money, time, and stress. Knowing the basics gives you power. Spot a bad deal, know your options, stand up for yourself. If a contractor botches your kitchen, contract law means you don't have to accept it. Slip and fall in a store? Tort law might have your back. You don't need to be a lawyer, just a responsible adult. Like knowing when your car needs a mechanic. You should know when a situation needs legal help. This knowledge helps you ask the right questions and protects you from being taken advantage of. Read what you sign. Understand your promises. Know your duties. The law isn't mysterious. It's there to keep society running. The more you know, the more confident you'll be. Don't be a spectator. Know the rules, play smart, and take responsibility. A classic example of a Supreme Court ruling that rejected a plaintiff's claim is the case of Dred Scott v. Sandford, 1857, where the court ruled that Dred Scott was not a citizen and had no standing to sue for his freedom, essentially against the plaintiff's interest. Although this ruling was based on constitutional interpretations, not common law, many Supreme Court rulings involve common law principles and can result in judgments against the plaintiff. In Dred Scott v. Sandford, 1857, Dred Scott, an enslaved person, sued for his freedom. The Supreme Court ruled against Scott, stating that he was not a citizen of the United States and therefore could not sue in federal court. The court reasoned that enslaved people were not considered citizens by the Constitution, and the plaintiff had no standing to sue on that ground. The decision denied Scott's claim and reinforced the legality of slavery at the time, effectively ruling against the plaintiff's cause. In any lawsuit, the plaintiff bears the burden of proving their case. The plaintiff must have standing, meaning they have suffered an actual or imminent harm that a court can address. If the plaintiff cannot demonstrate this, their case can be dismissed. Many Supreme Court rulings involve interpreting the common law, which is the body of law developed through judicial decisions rather than statutes. Even if the ruling isn't a pure common law case, common law principles like precedent and stare decisis are often crucial in Supreme Court decisions. The Supreme Court is a common law court because it relies on precedent, meaning it looks to past rulings on similar cases to make its own decisions. A Supreme Court example of common law is found in Erie Railroad Co. v. Tompkins, 1938, a landmark ruling that announced there is no federal general common law, but federal courts can create federal common law when a rule of decision is necessary to protect uniquely federal interests. For example, in Morissette v. United States, 2024, the court considered common law fraud principles to interpret federal securities laws, indicating that statutes are not always written on a clean slate. Morissette v. United States, 1952. In this case, the Supreme Court had to interpret a federal statute regarding the unauthorized removal of government property. The court drew upon the principles of common law larceny to determine the elements necessary for a conviction under the statute. The ruling in Morissette demonstrates how the Supreme Court uses common law doctrines to interpret federal laws by applying the established meanings of those legal terms. An example of common law is common law marriage, a legal concept where couples who live together and meet certain conditions can gain the same rights as officially married couples, even without a marriage license. Other examples include contract law, where judges set standards for agreements, and tort law, which deals with civil wrongs like car accidents and negligence. Judges create common law by applying legal precedents from previous court decisions, a concept called stare decisis. Common law marriage, a relationship that is legally recognized as a marriage without a formal license, provided the couple meets specific requirements. Typically involves openly living together, presenting themselves to the public as a married couple, and sometimes combining finances or sharing property. To grant partners legal rights and responsibilities, such as those related to property division or inheritance, similar to those with a formal marriage certificate. When two people make a binding agreement, for example, buying a car for $1,000, common law principles dictate what makes the contract valid and what happens if one party doesn't uphold their end of the agreement. This area of common law addresses civil wrongs, such as a driver causing an injury in a car accident. Judges rely on prior court decisions in similar accident cases to determine the intoxicated driver's liability for the victim's damages. Right to habeas corpus, this fundamental common law protection requires that anyone detained be brought before a court to determine if their detention is lawful. How common law works, stare decisis. Judges don't create laws from scratch, but rather interpret and apply the principles established in previous court cases, precedents to new situations. Judge-made law. Common law is also known as judge-made law because it is developed by judges through their decisions in individual cases, rather than being written by a legislative body. Common law is adaptable and can change over time to reflect evolving societal norms and circumstances. When a statute, a written law passed by a legislature, contradicts common law, the statute generally takes precedence. Ever wondered what it actually takes to work a civil lawsuit from start to finish? Let me pull back the curtain on the whole process. No law school jargon, just the real steps lawyers take in a common law case. So, first things first. Before anything even hits the court, there's a pre-litigation phase. I dig into the facts, gathering docs, building a timeline, and listening to my client's whole story. Then comes the legal research. This is where I dive deep statutes, case law, and especially judicial precedents. Because in common law, what happened in similar cases before can make or break mine. If things look solid, I usually send a demand letter to the other side, trying to resolve things without a lawsuit. A lot of cases actually settle right here, way before we ever see a judge. But if we can't settle, it's time to file suit. The pleading stage starts when I draft and file a complaint with the court, laying out exactly what my client says happened and what we want. Then I make sure the other side, the defendant, gets formally notified. They have to respond, usually by filing an answer addressing every single allegation. Sometimes they'll even countersue, flipping the script. After that, things get real with discovery. This is the marathon part, where both sides exchange information to figure out the strengths and weaknesses of each case. I send interrogatories. Those are formal questions under oath. I request documents, emails, whatever's relevant. Depositions happen too, live, sworn interviews with witnesses, all recorded. And sometimes I'll send over requests for admission to get the other side to agree on basic facts, so we can focus on what's really disputed. Heading into pretrial, both sides might file motions, like a motion for summary judgment, basically arguing the case should be decided without a trial. There's also a pre-trial conference with the judge, where we set timelines and maybe squeeze in one last settlement talk. If everyone's still at odds, we prep for trial. This means organizing all the evidence, prepping witnesses, and planning out opening and closing arguments. I practice how I'll present the case, because clarity and confidence matter. Trial itself is a whole production. Jury selection, opening statements, back and forth with witnesses, and presenting all those documents we dug up. Each side gets a final shot to sum things up in closing arguments. Then, the judge tells the jury what law applies, and the jury heads off to decide who wins. But it's not always over there. After the verdict, the losing side can file post-trial motions or even appeal, arguing the judge made a legal mistake. So yeah, working a common law case is all about careful prep, knowing the rules, and respecting precedent. Most cases settle, but if you go all the way, every step counts. Law isn't just about arguing. It's about strategy, evidence, and making your case crystal clear. Here's a Supreme Court decision every legal professional should know. Cummings v. Premier Rehab Keller, decided in 2022. It's a case that completely reshaped the landscape for private plaintiffs in disability discrimination lawsuits, especially when it comes to recovering emotional distress damages. Let me break it down. Jane Cummings, who's deaf and legally blind, needed physical therapy. She asked Premier Rehab Keller, the clinic, for a sign language interpreter. The clinic refused, saying other communication methods would do. Cummings sued, arguing this denial was discrimination under Section 504 of the Rehabilitation Act and the Affordable Care Act, since Premier Rehab takes federal funds through Medicare and Medicaid. But here's the pivotal twist. The lower courts dismissed her case, saying the only damages she was claiming were for emotional distress. Nothing financial, no out-of-pocket losses. The Fifth Circuit agreed on appeal. So what happened when it hit the Supreme Court? In a 6-3 decision, the court sided with Premier Rehab. Chief Justice Roberts, writing for the majority, focused on the spending clause of the Constitution. When Congress attaches conditions to federal funding, recipients need clear notice of what they're signing up for, including liability for specific types of damages. Because neither the Rehabilitation Act nor the ACA explicitly mentions emotional distress damages, the clinic wasn't on the hook for them. Importantly, the court didn't decide whether Premier Rehab discriminated. The only issue was this: can you, as a private plaintiff, recover emotional distress damages under these laws? The answer, after Cummings, is no. Unless Congress says so, those damages are off the table. Now, why does all this matter? This ruling narrows the path for private recovery in federal disability discrimination cases. It means emotional distress alone isn't enough for a payday, at least not under these statutes. And it reinforces that Congress has to be crystal clear if it wants to make federal funding recipients liable for these kinds of damages. Otherwise, courts won't fill in the blanks. Let's zoom out. This isn't just about disability law. It's a message to every legal pro. Know what damages are actually available under the statutes you're working with. Emotional distress, reputational harm, even punitive damages. It all hinges on what Congress wrote, not what feels fair in a given situation. And for those who argue Cummings guts private enforcement of civil rights, maybe. But it also clarifies the rules of the game for both plaintiffs and defendants. If you're advising clients on either side, pay attention to statutory language. Bottom line, the Supreme Court drew a bright line, and unless Congress acts, emotional distress damages for these federal discrimination claims are a no-go. Ever wondered how most civil lawsuits get resolved before ever seeing the inside of a courtroom? If you're a law student, buckle up, because I'm breaking down the real secrets behind winning a private law case, without even going to trial. Let's start from the top: pre-litigation. This is where the magic, or should I say strategy, really happens. Before anyone files a lawsuit, there's usually a ton of back and forth. I'll meet with my client to get the facts straight. What happened, when, where, and why it matters. Then comes some classic detective work, digging through documents, talking to witnesses, and figuring out if there's even a case here. If things look promising, I'll send a demand letter to the other side. Think of it as an official "let's settle this like adults" invitation. Most of the time, this kicks off negotiations. If we can agree, boom, case closed, time and money saved. But if talks stall and my client's still on board, we lock it in with a retainer agreement and prep for battle. But sometimes there's no deal. That's when things get official. I'll file a complaint spelling out what my client wants and why. Then the defendant gets served and has to answer, either denying, admitting, or throwing in some counterclaims of their own. The court sets the ground rules with a scheduling order, and now we're officially in the thick of it. Next comes discovery, the legal world's version of show me what you've got. Both sides trade questions and demand documents. We might depose witnesses, grill them under oath, and issue subpoenas if someone's playing hard to get. It's all about building the strongest case possible, or poking holes in the other side's story. When discovery wraps, it's crunch time. I might file motions to get weak claims tossed, or try to keep sketchy evidence out. There's usually a pre-trial conference with the judge where we try, one last time, to settle the case. Courts love alternative dispute resolution, so mediation or arbitration is almost always on the table. If all else fails, I get my exhibits lined up, prep my witnesses, and get ready for trial. Now, trials are dramatic, sure, but they're not always the best way to win. First, we pick a jury, if there is one, make opening statements, and then the real action starts. Witness testimony, cross-examinations, and presenting every scrap of evidence. After closing arguments, the judge or jury decides, and the court enters judgment. But even then, it's not over. If I lose, I can file post-trial motions or appeal, though that's a whole different ballgame. And if I win, sometimes I still have to chase down the money or enforce the judgment. Here's the real secret. Most cases never reach trial. The best wins often happen through settlement, negotiation, or mediation, long before a judge bangs the gavel. My job is to understand every legal angle, prep obsessively, and guide my client to the smartest outcome, whether that's a courtroom victory or a handshake deal. So if you want to win a civil case, remember, it's all about preparation, strategy, and knowing when to fight and when to settle. And always, always get yourself a good attorney if you want to stay sharp on landmark cases and how they shape everyday practice. If you found this breakdown helpful, make sure you're subscribed for more law school secrets and real-world legal tips. Thanks for watching. See you in the next one.